Please state your name for the court.
My name is Corey Hyde.
What do you do for a living?
Well, I am the executive assistant for Miss Ava Bancroft. That being said, I tend to do a lot that involves her personal and professional life. I do everything as far as getting her food to planning out her business meetings, as well as briefing her on any sort of legislation being brought forward or any sort of major movement in the casino world.
Did your job involve working on her recent casino proposal?
Yes, it did. I was assigned actually to draft a proposal for the next casino that Miss Bancroft wanted to open.
And did you ever speak with anyone in the Midlands Gambling Commission when doing this?
Yes, I received a call from a man who introduced himself as Auditor Mickey Keenan in regards to that proposal that I turned in to the Office of Chase Custom.
Now, in the casino world, what does an auditor do?
Well, an auditor is in charge of looking through all of the financial documents of a specific company. Specifically, Officer Keenan was in charge of looking through all the financial documents of the Black Bear Casino, to my knowledge, as introducing himself as an auditor.
Now,
Objection, Your Honor, to lack of foundation. This witness hasn't given us any testimony in regards to how he would know what an auditor does or the daily jobs of an auditor. He can't testify as it's out of his knowledge.
Response.
this witness has told us that he is the personal assistant, the executive assistant to Miss Avery Bancroft, who runs a successful casino. He's told us he's very involved in her personal and business affairs, meaning he's involved in the business affairs of the casino. He's very qualified to tell us what an auditor does in the context of the casino business. Well, he certainly can't tell us what an auditor would do outside of that context. He was telling us what an auditor does at a casino, and he's certainly qualified to tell us that based on his work experience.
I'm ready to respond on those grounds.
Sure, go ahead.
Your Honor, he stated that he's simply an executive assistant, and that's it. He hasn't given us any testimony that would allow him to talk about what the Midlands Gambling Commission does and how an auditor works with that Midlands Gambling Commission. Now, if they can lay that foundation, then this testimony may be allowed, but yet they have not laid that foundation.
If I may respond, Your Honor?
No, that's all right. I think he has sort of told us within his realm of knowledge, or what he understands them to do. I think beyond that, it's not all that harmful really here, so I will rule that objection.
Yes, Your Honor.
You called him Officer Keenan, so when did you learn that he wasn't an auditor?
Well, I met with Officer Keenan on March 2nd, and that was just an informational meeting where I was going to pitch that proposal to him and walk him through all the specifics of that proposal that we had so far. And halfway through that meeting, he slid a badge over to me and introduced himself as an undercover investigative officer.
Now, was Detective Keenan the only officer you had contact with?
No, Officer Keenan was not the only officer I had contact with. I was actually trained and briefed by many officers throughout this process up until the March 31st meeting where I wore a wire to that meeting.
So now, at that meeting, who was going to be there?
Well, on March 31st, that was just Ava Bancroft, myself, and Officer Keenan.
And you said you wore a wire.
Yes, I did wear a wire. That entire conversation was recorded.
Now, were you given any instructions on what you should say or what you should do in that meeting?
Yes, just prior to that meeting, I had received an email from Officer Keenan telling me what I was supposed to do for that meeting.
And did you speak with any officers before that meeting?
No, just Officer Keenan.
Now, at that meeting, was there ever any mention of a bribe?
There was a mention of a bribe. It happened actually just as I was reaching to pick up my phone. There was a flush over the recording, but yes, there was a mention of the bribe at that meeting.
Now, do you remember how Avery Bancroft reacted?
She was completely taken aback. She said that she had never done anything like that before. To the best of my knowledge, working with her, she never
Objection,
has.
Your Honor, to hearsay.
Response?
Your Honor, this is hearsay, but it falls under an exception under Rule 803.2 as an excited utterance. Now, Avery Bancroft had just been asked if she would be willing to commit illegal activity. She was understandably very taken aback. As this witness told us, she was flustered, she was shocked, and this was an excited utterance because it was a reaction to the stressor of being asked to perform something illegal. This qualifies as an excited utterance because of that stressor, and it is an exception to hearsay and is admissible.
What's your response to that?
Your Honor, we have a good faith belief that this is not excited utterance, as the mention of a bribe simply doesn't allow someone to be as prized as they're claiming them to be. Now, excited utterance is, by law, a statement relating to a startling event or condition made while the declarant was under the stress of the excitement that it caused. Now, they're saying that he just was taken aback, but that doesn't clearly see that there's an excitement here, that there's anything to really be yelling about. And that simply doesn't constitute excited utterance for this hearsay.
Can you remind me what the statement was that Bancroft was reacting to?
The statement was, although the specific statement wasn't given, the statement was Mickey Keenan asked specifically about a bribe. And now, under the law, as opposing counsel said, the important point of analysis here is what the stressor was. Is this a startling event? And the answer to that is yes. A member of a government body, the Midlands Gambling Commission, had just asked Avery Bancroft if she would be willing to engage in illegal activity. That certainly qualifies as a startling event and would qualify as a stressor that would induce an excited utterance under Rule 8032.
Your Honor, if I may.
I have more questions for counsel here. So, you said that he didn't tell us what the statement was that Bancroft reacted to. Do we know what that statement is, just in general?
Well, definitively, Your Honor, no, we don't. As the witness also mentioned, there was some static on the recording because he brushed the microphone, so we don't have the exact wording of the statement. But this witness can testify that, to the best of his memory, that statement was asking about a bribe, and the word bribe was most definitely mentioned.
Your Honor,
Yes.
I specifically remember the witness testified that Avery Bancroft said, no, nothing like that. Now, that is a statement and it asserts truth value, and therefore it is hearsay and does not constitute excited utterance. As he said, he thought that they mentioned a bribe, but never clearly stated anything about a clear, unambiguous question as to a bribe. Now, that doesn't constitute excited utterance because there was no clear definition of a bribe mentioned, and it should not be allowed in court today.
I'm going to agree with counsel. I don't think I have enough here to say that there was enough of an exciting event to cause Ms. Bancroft to just blurt something out. So I'm going to sustain that objection.
Yes, Your Honor.
Will that testimony be stricken from the record?
Yes, that was true.
Yes, sir.
Now, after that meeting, did you set up another meeting?
Yes, I did set up another meeting. It was on April 13th, and that was between Chase Covington, Ava Bancroft, myself, and Officer Keenan. And that was a pretty formal meeting. That was our chance to move beyond Mickey Keenan and pitch our proposal to Chase Covington directly.
Now, what happened at that meeting?
Well, it started off very formal. We were talking specifically about the schematics for the proposal itself and the casino until Mickey Keenan began glaring at Ava Bancroft.
And what did Avery Bancroft do?
Well, Ava Bancroft obviously looked at Mickey Keenan and acknowledged the glare and said, "That's all well and good, but I think Mickey here wants to know what I can do for you."
Now, in this meeting, we heard about a napkin that was slid across the table. Do you remember that?
No, I do not.
So, do you remember, were you there when that napkin was written on?
No, I was actually in the bathroom for that period of time.
Objection, Your Honor, to testifying. He just said that were you there when the napkin was written on? He hasn't laid any foundation as to how this witness would know that the napkin was written on, and he's testifying on the record.
I'll agree with that. If he wasn't there, I haven't heard enough that he even knows that this napkin exists, especially based on his testimony that he just said he wasn't in the room when any such napkin might have been created. So I'll sustain that objection, but if you can lay the foundation, I won't strike the testimony.
Yes, Your Honor. Now,
Yes, sir.
Mr. Hyde, at any point, did you ever see Avery Bancroft write on a napkin?
No, I did not.
So, did you ever hear any conversation related to writing anything on a napkin?
No, I did not.
Now, after that meeting, were you still trying to get this casino proposal?
Oh, of course we were still trying to get that casino proposal. I mean, Mickey Keenan being there as an auditor kind of stressed out the rest of the company. I knew he was there as a
Objection,
return
Your Honor,
officer.
speculation as to Mickey Keenan being there stressed out the rest of the company. He can testify to his knowledge, but he can't testify to the mindset of anyone else.
Response?
Yes, Your Honor, and I'd be happy to rephrase the question to confine the answer to this witness's mindset.
That works.
Will that testimony be stricken from the record? as to everyone being stressed.
Yeah, I guess we'll strike it, that's fine.
Yes, sir.
When Mickey Keenan showed up, why were you stressed?
Well, at first, I was under the impression that he was an auditor. That being said, he was going to be going through all of our financial records for the Black Bear Casino, and financially, we were not doing as well as we should have been.
So was Avery Bancroft Entertainment in financial trouble?
Not in the short term, not immediately, but our long-term economic projections did put us deeply in the red. That being said, we started an aggressive buyout program for small businesses where Avery Bancroft picked up many failing small businesses and flipped them for an immediate profit. It was our intent to use that profit to create the centerpiece of our plan for our economic comeback, the new casino.
Now, when you and Avery Bancroft finally did realize that you were being asked to offer a bribe, why didn't you just walk away?
We tried everything. We pitched it directly to Mickey Keenan, who made it very clear that the casino was not going to get through unless we offered a bribe to Chase Covington. We pitched it directly to Chase Covington, and again, Mickey Keenan made it abundantly clear that it was not going to get through unless we offered a bribe.
Objection, Your Honor, to hearsay as to the statements made by Mickey Keenan.
Response?
These statements are not hearsay, Your Honor, because they're not being used for the truth of the matter asserted. Now, we're not attempting to prove that this casino proposal would or would not have gone through with or without a bribe. We're only trying to show that Mickey Keenan told that to Corey Hyde and to Avery Bancroft and the subsequent effects it had on the listeners. This is not being used to prove the truth of the matter asserted, only the effects on the listeners, and thus it's not hearsay and is admissible.
Okay.
Your Honor, that goes directly to the truth of the matter asserted. He's trying to say that Mickey Keenan made it clear that this would not go through without a bribe, which is exactly what's contested in today's case. They are using it for the truth of the matter asserted, and it should not be allowed to work.
Your Honor,
I'll give you one more response because I'm somewhat inclined to agree.
the truth of the matter asserted is this won't go through without a bribe. We're not trying to show that the casino would or would not go through without a bribe. Rather, Corey Hyde and Avery Bancroft thought that it wouldn't go through without a bribe. Because of these statements, they were under the impression that bribe was their only option. Whether or not it actually was their only option, which is the truth asserted in those statements, isn't relevant to today's trial, and we're not trying to contest that or show that one way or the other. We're only trying to show that because of these statements, Corey Hyde and Avery Bancroft thought that a bribe was their only option. And thus, it goes only to the effect on the listener and not to the truth of the matter asserted. It's not hearsay.
I'll give you the last word.
Your Honor, I think they're using this, they are using this directly for the truth of the matter asserted, as they're trying to say that Mickey Keenan was telling Mr. Hyde and Avery Bancroft that this would not go through without a bribe. That's exactly what is contested in today's case, and they're using it for the truth of the matter asserted, except for the fact that they're trying to get this in on an effect for the listener.
I will overrule the objection, but give counsel, I guess, a stern warning that this should only be used for the effect on the listener in the closing argument, and that a limiting instruction will be given to the jury to that effect.
Yes, sir.
So
Yes, sir.
overrule.
So, when you realized, or at least when you thought, that a bribe was your only option, why didn't you just walk away?
Because we couldn't. As I said before, our long-term economic projections put us deeply in the red, and we needed this casino in order to survive.
Thank you. No further questions, Your Honor.
Cross-examination, Your Honor.
Yes.